Jon Paul Rion, Jonpaulrion,
Rion.
attorney for Gregory Moore.
Ryan, right? You pronounced that Ryan.
Correct.
Yeah, yeah. All right. So he's pleading not guilty, and of course everybody wants to know, how do you prove he didn't do it based on the evidence they've laid out?
Well, first of all, we don't have to prove he didn't do it. The burden of proof is on the state. Second of all, I didn't hear any new evidence come out today from the state. It appears to be the same evidence that they didn't have 12 years ago that they're just repeating again. I know for a fact that some of the information that they just stated is not true, and we'll be able to prove that very easily at trial. So at this point, the case is just beginning. When we said he's not guilty, that means we will be going to trial on this matter. This case will go to trial, and Mr. Moore has much to say in his own defense in this case.
And Jon Paul, what is his temperament right now? He seems like he appeared a little bit emotional.
Well,
He puckered his lips and he put his head down a few times. What is Gregory Moore's temperament right now?
put yourself in his shoes for a second, being charged with crimes that you don't believe you committed, and then put yourself in front of this crowd and in the news, in the courtroom with these charges. Of course you're going to be concerned. His life is literally on the line here. And if he's innocent, he should have a lot to be concerned about. Our system's fragile, but good. And we trust in the system, and we're waiting for our day in court.
And you did say in that motion that you thought the charges were vague. Can you expand on that a little bit?
I did not hear any information in the indictment or today that would indicate that there's any new evidence. The information that they pointed to, again, we have specific evidence that contradicts that. And we've just started our investigation. They've had 12 years to do theirs, but we know that part of the information they provided just is not accurate. So we'll put our case together. We'll implore or get the experts that we need to take care of this case, and we'll present our case to this jury.
It's a high
What has he said to you about this? I mean, these are serious charges. 6 counts of murder, 1 count of aggravated murder, and counts of kidnapping and conspiracy. What has he said to you?
He said today what he's been saying for 12 years. He did not do this.
What new information can you say? I know you're saying you can, dispute what they're saying, but is there anything new you can tell us right now?
Not yet. I want to get the information. I want to make sure, that, as you said earlier, that we're working off evidence. Firm, strong evidence. Not politics, not conjecture, not just an idea or an imagination as to what happened, but actual evidence. That's what we're looking for. We have a bond. You have a constitutional right to bond. A bond was set. We will be going back to the judge to reconsider. This man stayed in the community this entire time. He hasn't moved. He hasn't left. He hasn't done anything except for stayed in the community and continued with his life.
What bond would you be satisfied with?
A reasonable one.
Well, you're talking about, vague and no new evidence, but, they've laid out a very specific electronic trail with cell phones disposed of and taken off the network and those kinds of things. That's not vague.
If it's true, you're right. But if it is not true, then it creates some problems. We'll wait for the trial to bring this forward. I'm not a great fan of trying a case to the press. I think all the information has to come out, and it's unfair to both sides, really, for each to just give canned answers. We'll wait for trial. We have specific evidence, though. We're not just working off of just an idea.
Were you surprised when the indictment came after 12 years?
As we all were. Again, there did not seem to be any major break in the case that allowed for such a drastic action. The timing is interesting. If there were witnesses that have passed away or they're no longer with us, and the opportunity to cross-examine them or subpoena them or to have them present their case in court, if that's no longer available, obviously that creates issues. And the timing will be looked into as a basis.
Did you talk to your client this morning?
Of course.
And what was his frame of mind going in this way instead of being on the other side of you?
Well, we answered that question. Obviously, facing this type of a charge would cause any of us to be concerned.
What are your next steps, Jon Paul?
Next steps are to get the discovery from the state, review it, analyze it, interview our witnesses, and go to court.
Are you confident that you'll have the outcome that you want in the courtroom?
Let's be fair about this. I think if you're a doctor and all you have is one little symptom of an issue, you want more information before you diagnose it. But in the end, from what I know so far, and from the information that's been just vaguely presented today, we know that part of the platform the state's resting upon is not accurate.
Has he ever
Thank you.
suggested who that, has he ever